Good afternoon. My name is Judy Zeiner, and I'm Vice President of Operations with Lieberman Management Services. On behalf of LMS, I'd like to thank you for dedicating your time to join us today for this educational webinar session. This program covers important guidance related to your volunteer service as an association or corporation board member. It will last approximately 45 minutes with time after for Q&A. Should you have questions, please submit them through the chat window on the top right of your screen or by tapping the question icon on your tablet or smartphone. Please address those questions to the meeting organizers labeled Judy Zeiner and Howard Dakoff. Attendees will be muted during the presentation. Please note that this presentation is being recorded and will be available for review on our website, liebermanmanagement.com, and on YouTube. Joining us today is our featured presenter, Attorney Howard Dakoff. Howard is a partner heading the Community Associations Practice Group of Levenfeld, Pearlstein, LLC. He concentrates his practice in condominium, real estate, and general corporate law. Howard is the co-author of the current chapter on condominium management for the Condominium Law textbook, published by the Illinois Institute for Continuing Legal Education. Howard also regularly publishes articles on a variety of community association topics and lectures extensively at state and national seminars. You may recognize Howard's name as the weekly columnist for the Chicago Tribune Sunday edition as the Condo Advisor.
Thank you, Judy, and thank you to Lieberman Management Services for allowing me this platform to speak with your clients, to give them a little boot camp of information on being a board member. My goal today is to arm all of you listeners out there in internet land with information that is practical, that is knowledgeable for you, that you can utilize in your community associations, whether it be condo, community, or co-op, and practically make a positive impact as part of your board service. To be honest, each of these topics that we're going to talk about could be an entire lecture in and of themselves, so we're going to really be talking from a high level, and to the extent you have any follow-up questions about anything we covered today, please contact Lieberman, your property manager, and your supervisor, and they will get you the necessary information you need so you can service your board as best as possible. So where do we start? Condominiums. Well, there's a governing document hierarchy in condominiums, and it goes something like this. There's three levels. You have state law, you have your declaration and bylaws, and then you have rules and regulations. State law trumps everything, meaning if a provision of the Condominium Act exists and your condominium declaration has something inconsistent with the Condo Act, even though you may not know it, that condo declaration provision is void because it's inconsistent with the Condo Act. So for a lot of older declarations where board members actually read the declaration and bylaws, they think they're complying with what the governing documents say. But unbeknownst to them, over the last 15, 20 years, there's been a tremendous amount of amendments to the Condo Act. Some of those provisions may be modified or void. So to the extent you have questions, you need to talk to your property manager. Then you have the level of declaration and bylaws. This is really the instruction guide with how a community and condominium association administers itself. It has certain rights and obligations of both the board and the unit owners. So for instance, the board usually has to maintain, repair, and replace the common elements. They also need to collect income to do that. The unit owners have certain rights to object to certain decisions, to be a part of certain decisions. And so the declaration and bylaws outline that. The lowest level, but not any less important, are the rules and regulations. And I say that because the rules and regulations, as a practical matter, is the handbook that most of you live your day-to-day basis by. It has the rules on how to use your recreational facilities, your common facilities, rules on garbage, rules on pets, rules on construction. That's really how you navigate within your community association. So, as a general rule, a declaration, a condominium declaration is a recorded document. That means when you purchase your condominium unit, whether you read it, the declaration or not, or whether you even knew there was such a document, you are bound to it. You are agreeing explicitly to comply with the terms of it. So as a board member, you should review it, if nothing else, to be familiar with the general sections of the declaration, because that is what you are fulfilling. You are maintaining, repairing, and replacing common elements. It has provisions on insurance. It has provisions on whether the unit owner or the association is responsible for certain maintenance. It will have provisions on easements, meaning what can the association do and not do. It'll have, most importantly for boards, a remedies provision. When there's a violation of the governing documents, what rights does the board have to enforce? The most common question. We learned of unit owner X is doing something in violation of the documents. What can we do to stop it? And the remedies provision is there. It forms the legal obligation for owners to pay assessments, and similarly for the board to collect it. It identifies the unit owner's percentage of ownership, and it also has the amendment provisions. In Illinois, just for edification, no condominium document can have less than 2/3 of the unit owner approval or more than 75%. So if the question from an owner or a board member is, we want to revise our declaration to make up the topic. We want to add leasing restrictions. We want to remove leasing restrictions. We want to add pet restrictions. We want to remove restrictions on board authority. Whatever the issue is, your declaration can have no less than 2/3, no more than 75%. I see in a lot of older declarations amendment provisions saying 80%. Seem to have been somewhat common back in the 60s and 70s, but that's void because now the state law says a maximum of 75%. The bylaws. The bylaws are basically the instruction manual of how the board works, the procedures, policies and procedures. Who's elected? What is the qualifications of a unit owner to serve on the board? How many meetings must there be? Where? What positions on the board? What is quorum? All of these election procedures and governance issues are contained in the bylaws. And as I said earlier, the rules and regulations are basically a guideline for harmonious living. A community association by its nature is either vertical, you're in a high-rise, or a mid-rise, but you're living on top of each other, literally and figuratively, or it's horizontal. You're in a suburban community association, and you're living next to neighbors, but you're all subject to the confines or the regime of a community association. Your rules govern your day-to-day living. So the board. What do we know about board members? Unless the governing documents allow compensation, all board members volunteer their time. At the most basic level, they're administering the common elements, which is the property the association owns. And there's some legal boundaries within which they must do that, and we'll talk about that in the next few slides. State law says there must be a minimum of 4 meetings per year. In a Chicago high-rise, for instance, monthly, except maybe 1 month in the summer and 1 month maybe in December, unless the annual meeting's in December, may be common. For smaller associations, they won't meet as regularly. They will delegate to the managing agent the responsibilities, and they may meet 4 to 6 times a year. A trend that we are seeing that is really important for you to appreciate and accept. Condominiums and community associations, almost exclusively when I started practicing over 20 years ago, will have meetings at night in person. There was a feeling that they needed to sit in front of the owners and have a dialogue, and everything occurred in person. And then in 2014, we had a case called the Palm 2 case, which we'll talk about in a minute, and it added a layer of formality to communications of the board. And so then boards started meeting regularly to comply with the new requirements in the law. And board members started having fatigue because meeting monthly and sometimes calling meetings in between to make decisions would become burdensome. And so boards throughout this state have been increasingly utilizing teleconference software to call meetings because it's addressing the fatigue. Board members are busy. Getting a quorum of the board members could be difficult. depending on the constitution of the board. And so what we have is a 800 number that would allow the community members to call in so that unit owners can participate by listening. Board members can either be in person in a physical location or call in themselves, and the board meeting would happen telephonically. And we're seeing a trend of daytime meetings, usually at lunchtime, not trying to create obstacles for the owners to listen, but to address more frequent meetings. Legal obligations. I'm not going to read each one of these next two slides. You can see 7 cases here. The general gist, serving on a board comes with its certain responsibilities. You are running a business. Your business value is the aggregate value of all the units. So if you have 100 units and the value of all those units is $23 million, for instance, you're running a business with assets of $23 million. Your budget is your budget. That's what you collect assessments to pay your expenses. And so when you think about it like that, running a business in a corporate perspective, you have certain responsibilities. You have the legal responsibility to look out for the best interests of the association and the owners. If someone said, put in simple English, what is a fiduciary duty? It's you must act in the best interests of the association. And your legal standard to do that is reasonable business judgment. Now, you may say, Howard, what's reasonable to our building may be different than the building next door, and I would say you're absolutely correct. There's no set standard on every decision has to be consistent among different associations. It merely needs to be reasonable. So as you're going through this slide, and you look at the case law on the next slide, I get into what the holdings are to create an image, but really to create the sense that there needs to be a formality to your board service, because you are held to a slightly higher legal standard than a simple unit owner. You are running a business, and you must do so within the bounds of the law. So, the conclusions are really what you need to know. Board members consistently ask, well, could I be liable for breach of fiduciary duty? Could I be sued for breach of fiduciary duty? Well, the answer in the most abstract sense is maybe, but not practically. First of all board members sitting on this webinar should ensure that their association has D&O insurance. It stands for Directors and Officers Liability Insurance. That's the insurance policy that if you are sued as a board member will provide legal defense. Secondly, as long as board members use their reasonable decisions and do not commit gross negligence or make willful and wanton decisions and rely on the advice of professionals, board members will not be held liable for breach of fiduciary duty. As a practical matter, boards are sued, but that does not mean that the suit results in liability. Very rare. The circumstances need to be quite significant of misconduct for a court to hold a board member for breach of fiduciary duty. And it's basically number 3. You can make mistakes, that's okay. You can make bad decisions, that's okay. But you cannot make reckless decisions or ignore the law. Okay? So let's talk about the role of officers. Board presidents. Don't know how many are sitting on this webinar, but I'm sure a few. What do you need to know? Well, the Condo Act says you preside over the meeting, and you're generally the designated point of contact with the managing agent. In fact, most managing agent management agreements state that the board president will be that individual unless the board elects to assign someone else that responsibility. Customarily, board presidents sign legal documents. They're the liaison with lawyers or accountants unless there's an individual appointed, and you carry out the decision of the board. What do you notice is not on that list? Board presidency does not give that board member superior rights to make decisions by him or herself. The board president does not have a fiefdom. You are merely the representative of a board of directors, and you carry out the decision of the board of directors. As a practical matter, you are the face of the board, So there is a higher level of interaction with the owners, but you have no additional legal rights merely by having the title of board president. Treasurers. Treasurers, I'm sure there's a few on the line. I've got a chat. Somebody said I'm a treasurer. Thank you for the feedback. Your responsibility is to review financial statements. But frankly, all board members should be reviewing financial statements, because in order to make informed decisions, you need to have a snapshot of where your association is financially. But the board treasurer usually takes the lead on reviewing, is usually on the committee to help with management develop an annual budget, usually is the individual who makes recommendations to the board, because it's a board decision on reserve funding and investments, and is usually the individual who's the signatory for financial aspects. Once again, as a board treasurer, what do you not see? You do not see the right to sign checks without board approval, whether to yourself, your friends, your family, or because you believe you got a better deal on a contract. Those are decisions of the board of directors. You are merely an instrument, an individual who carries out the decision of the board. Secretaries. I'm sure there's a couple secretaries out there, board secretaries. Your primary responsibility is to draft minutes. And you are generally the person who maintains records unless you're professionally managed, in which case your management agreement usually says the managing agent will maintain those records. So if you're a board secretary reading this saying, I don't have all the formal records, do not fret. Lieberman is doing that on your behalf. You will have to attest to signatures from time to time, whether it's an amendment to the governing documents in some contracts, and you may or may not be a signatory. Once again, you will see the board secretary gives you no superior rights over other board members. You are merely an instrument for documenting records. So what are some best practices? I get this question a lot at seminars. Give us a kind of bullet point of what we should be doing and shouldn't be doing. The list could be significantly longer. We probably could have an entire session on administering a condo, and this is a high-level presentation to arm you with information, but if I wanted to encapsulate the topic, it would be the most frequently asked questions. And so what do those go around? Minutes. Usually the board will draft minutes. It is generally not a management function. Board meeting minutes, what should be contained in them? They are a legal instrument to document a decision. It is not meant to be a transcript of everything discussed at the board meeting. The little asterisk here, caveat, is you may want to put some information that's not required, i.e. just the vote, because this is the primary way you can telegraph information to the owners who do not attend the meetings. So it is perfectly acceptable to maybe highlight an issue that's being discussed, but you need to be sensitive, because remember, this legal document will be given to prospective purchasers. So if merely because a board member wants to discuss a potential capital expenditure that nobody knows anything about, that a majority of the board does not think is necessary, if you start including discussions that are not decisions, it will lead to unit owners and potential purchasers thinking that there may be a set of issues that do not actually exist. So you need to be very careful with your choice of superfluous information. But I generally recommend it should be a little bit more than call meeting to order, quorum present, 3 motions and votes. You want to use minutes as a way to convey information to the owners. Unit owners forums. Unit owner forum is a common courtesy that boards allow owners to speak, usually just before or just after the official meeting. They are not required by law unless you are a community association. The Condominium Act does not require it, but the Common Interest Community Association Act does. So there's a small difference between condo associations and homeowners associations, but for a condo it is not required. If you are going to allow owners forum, we do not recommend that discussions, questions, answers be included in the minutes. The minutes reflect board decisions, not the opinions of owners who attend a meeting to express their concerns or to ask questions. And lastly, official records are kept for at least 7 years. So, let's do a quick primer of some of the most frequently referred to provisions in the Condo Act. This is not an entire seminar on the Condo Act. That may be a topic for a future webinar in the series, but for today, what do you need to know? Well, I've given you the section of the Condo Act, and I've given you the topic. The board must collect assessments, and that's covered in the Condo Act. The board prepares a budget, that's in the Condo Act. Section 9C also has the legal standard for the amount of reserve funding. There's a variety of factors in Section 9C. And they include things like the remaining useful life of the components, but also the burden to the owners, the return on investment, and the financial situation of the association. Boards must distribute annual accountings. That is a function if Lieberman is your managing agent, they are handling for you. You must hold open meetings. There is an exception. There are certain categories that you will discuss in closed session. That's the A, B, and C, threatened litigation, employment issues, unpaid assessments, and rule violations. Those are all discussions that are customarily held in closed session. I'm going to highlight the verb here. Discussion is in closed session, but the verb decision, or to decide, must be in open session. So for instance, if the board decides to initiate litigation, it's not delegated for collections to the managing agent, the decision would be a vote in open session. If the board wants to hire someone, that decision would be in open session. And similarly, if the board has a fine hearing, closed session, discussion, decision to levy a fine, open session. So what are the owner rights? Well, the owners have the right to observe open sessions, not closed sessions. Minutes of the open session will be kept. Minutes of the closed session not to be kept. And lastly, working sessions. Before the Palm II case, and we have a slide in a few minutes, this is a case that came down in 2014, and at the time shook the confidence of board members with an added layer of formality. The reality was it didn't change the law, it just was a strict interpretation of the law. And what came out of that case was, before 2014, boards would meet to discuss what would be decided at a board meeting. They prepped for their board meetings, and they had all of the discussions in what they called a working session, not an official meeting. And they would come to the meeting with a consensus among the board members of what they were going to decide. So the actual discussion in the board meeting was motion to approve. There was no discussion of all the background. And the court said that those are not allowed. Working sessions, email voting, straw polls, those are not allowed under the law. And that's a reality that boards need to work with. And there are some tools to address both the concerns of that case and the court ruling, and also as a practical matter, continue to administer your association. Maintenance, repair, and replacement, that's obvious. We've talked about that. The section is up on your slide. The association must maintain records, section 19. There were some changes that we can talk about in a few minutes. Insurance coverage, the association must maintain insurance, and it has to be consistent with the Declaration of Bylaws in section 12. And disclosures, section 22.1. That's a common term that you as a board member have heard, which is we have a 22.1 disclosure. It's a direct reference to the Condo Act. It says that a board must make certain disclosures for prospective purchasers, and it contains a variety of disclosures. Boards are wise to review their 22.1 disclosures on a regular basis because facts change throughout the year, and the disclosures you and your managing agent make, if they are wrong, could be problematic for an association. Because if, for instance, you fail as a board to disclose something that the law required you to disclose and the facts required you to disclose, and then one day there's a special assessment to pay for usually that expenditure, the owner who purchased at that time will come to you and say, I'm not responsible for that special assessment. You didn't tell me about it. You didn't disclose. And so that's an area of litigation that has really been more consistent in the last 10 years than the previous 30 years. So what are the authority of directors? Quite frankly, if you look at these, it's really what I've already been discussing. You collect assessments, you can access units for repairs, you can raise assessments without owner consent up to a certain amount. That's 15%. If your budget goes up more than 15%, the owners have a right to reject if they follow certain procedures. So your budgets, special assessments, for instance, are board decisions, but depending on the facts, owners may have rights to try and stop the decision. The board hires and terminates employees along with the managing agent, and then you adopt rules, and then you administer those rules. So what are the Bill of Rights of unit owners? Well, if I had to encapsulate it in 3 items, it's owners have a right to know how their money's being spent. And they have a right to inspect records, which is Section 19. They have a right to challenge increases in budget and special assessments. For those of you that have been on the board since last year, you are probably aware of an omnibus House Bill 189, which has been written about extensively, and I'm sure your managing agent has advised you of, which was a slew of amendments to the Condo Act last year. It took effect of January of 2018, January 1. And it basically was an added unit owner Bill of Rights. It gave unit owners more time to challenge decisions of the board, clarified procedures to challenge the board, gave owners more rights to documents that they weren't previously entitled to or information, and added additional restrictions on the condo association. If you're not familiar with that House bill, I recommend that you email your property manager, and I am sure they will provide you a summary that either Lieberman has or any of us law firms who work regularly with Lieberman's clients have summarizing the various holdings. So what are some board member best practices? What should you take away from today? Well, obviously you need to attend your board meetings and commission meetings. I would recommend you have a rudimentary understanding of what's in your declaration and bylaws. I would not suggest you try to read it right before bed. It may put you to sleep. But as a practical matter, you should know the topics that are discussed so that if an issue is raised, you at least are aware enough to know that there's some provisions in the document referenced so that you can then go back and look at it or ask your management team what the issue is. I would strongly recommend you review monthly financial statements and yearly audits. Many times special assessments that are unplanned occur because boards may not be as aware of the financial condition, and then one day an expenditure is needed to recoup money to pay for expenses that was unplanned. Knowing the financial condition of your association on a regular basis allows you to plan appropriately. That would not apply to planned capital expenditures that may require a planned special assessment. So I'm talking about the unplanned scenario. You obviously need to be aware of recent developments in condominium law. And so if you know nothing about House Bill 189, you can enter it into any of your internet search engines such as Google and you will get information. But I would also recommend you contact your property manager because you need the guidance from your managing agent on what it means. So it's one thing to read amendments to the statute, and sometimes it's very clear, but as a practical matter, you need to understand, well, what is the effect of this, and what do we really need to know? And then obviously confidential information. As a board, you are given the privilege of information about unit owners, you are given the privilege of information about employees, and that information should be kept confidential. You are not a mouthpiece for a secret anonymous newsletter to be divulging association confidential information. Not only could it expose an individual board member to breach fiduciary liability, could it expose an association liability to the extent it thwarts contracts, and of course, if the information is inaccurate and you defame somebody, it could be exposing both the board and the association to liability. So what's a general code of conduct? There's no such formal doctrine in any of the statutes, but if I had to highlight a couple topics, you know, the board needs to be leading by example, which means dignity, civility, and respect. You can have a spirited discussion as a board. You do not even need to be unanimous. If you're a 5-person board, it does not even need to be 4-1. A majority rules. The condominium association is a mini democracy of majority. But the discussions and the way you interact with the owners who may be upset about a decision should be conducted in a manner with really civility and respect. It may not make the decision any more palatable to those that object, but at least the discourse will be one of substance and not one of personalities or of vitriol that could be sent both ways to and from the board. I would say that as a board member, you obviously need to act with good faith because that's your legal obligation, is to act in the best interest of the association, and honesty. So when you characterize the facts of the association, you need to do so with honesty, not manipulating information that may be based in truth but not true to accomplish a narrative. It should be transparent. This is a condominium association, not a dictatorship of a totalitarian regime. And you need to act with care, diligence, and skill. That's basically the fiduciary responsibility. Just use your reasonable business judgment, and it will be different from building to building and from person to person. Utilize professionals to the extent necessary. Board members may have a variety of different professions, and it may not include a law background to understand what the law is. It may not include an engineering or architectural background to understand building systems. It may not include a corporate background on how to run a business. But that is exactly why you've been smart enough to retain Lieberman Management Services to be your partner in administering your property. And with that, I'm sure you have certain professionals as a part of the team that give the board information so that you, the board, can make sound business decisions. And the fact that it may be a different decision in the same community but the building next door, that's okay, as long as you get good information so you can make the best decision for yourself. Good conduct, I mean, that's almost preschool rules, right? Act with, good conduct. Support. When we have boards where they're divided, so if you're a 5-person board, I'm talking a 3-2 scenario, and the issue was very hotly contested. It's okay that the discussion was spirited, and that in this case, my example, 2 board members may be very unhappy with the outcome. But the board should be unified in carrying through to abide by the decisions. It's okay to dissent. Your dissent will be recorded in the minutes. And at the same time, you are a board and you have a lot of business to conduct, so abide by the decisions. Defamation, when owners are making accusations, innuendo, or inferences, it's easy to instinctively shout back, and maybe shout back colorful language. Be careful. Be careful what you say, because you're not just saying it on behalf of yourself. You're a member of the board, which exposes the board and the association to liability and minimize conflict. So, what are some practical takeaways? This would be one of the slides I would highlight to you. Your board meeting. Some of you on this line may be chuckling if you're one of those communities where your board meetings go 4 hours. No, that is not standard, and they should not go 4 hours. An average length for a well-orchestrated board meeting could be 1.5 hours. Some boards do less because they're very succinct. Some boards do more because they are bigger communities and have more issues. But an average should be 1.5 hours. Parliamentary procedure. The leading doctrine is Robert's Rules of Orders. Robert's Rules of Order. Common question, are we bound to follow it? The answer is no, unless your bylaws specifically say so. It is not standard for bylaws to say that community associations follow Robert's rules. Nonetheless, it is a guide, and it is a good guide on how to conduct meetings. Without parliamentary procedure, and some of you whose meetings may go longer than anticipated are probably shaking your head yes at this, what I'm about to say. People go on and on. There's no process. There's no time limits for discussion. There's no respect on having the floor. There's no motions to end discussion and vote to call the question. Work with your management team to develop at least a basic parliamentary procedure for you to follow if your community is one in which there is no parliamentary procedure followed to effectively conduct a board meeting. Have timed agendas. Give board members an opportunity to speak, but as I have already hounded, unanimous agreement is not required. It is okay to have dissenting opinions. Discuss one subject at a time. Sometimes it's easy to pretend you're in a what they call a whiteboard room. Imagine a dry erase board on all four walls in a room, and you can just throw ideas and start talking and jumping from topic to topic. Not an efficient way to conduct a meeting if you want to conduct business. One topic, discussion, vote. Next topic, discussion, vote, etc. Repetitive debate. You know, a majority of the board can cap a discussion, can end discussion, and call the question. So if the discussion is becoming less useful to making the decision, there needs to be the leadership to end the discussion, majority rules. And then if you are going to allow for homeowner forums, we recommend it's usually no more than 30 minutes, and usually it's a few minutes, 1 to 2 minutes per question, so that depending on how many owners are present. Pound 2 rolling. I've already alluded to this. I've already summarized it. What it is in 2014, our appellate court said no board workshops, no email voting. What's good about the case, the board may delegate powers. So let's talk about that for 1 minute. What does that mean? You, as a board, have the wisdom of hiring a managing agent. Your managing agent is in the business of managing real estate, and specifically condominiums. You, as a board, can delegate them to the power to make certain decisions and effectuate the day-to-day maintenance. Your management agreement already contains much of that delegation, but there are additional decisions that you can entertain to allow them to do. So, for instance, if your association has a right of first refusal, unless you delegate the managing agent to exercise it, unless a purchase contract value is too low, for instance, the board has to call a meeting to officially waive the right of first refusal. So you can delegate the authority to make that. You can delegate the authority to renew contracts, as long as there's no issue. You can delegate the authority to enter into certain contracts of a low dollar amount. Those are examples of giving the managing agent the authority to make the decision. That's what I'm talking about, the authority to make the decision. If you are a community that wants to make every decision yourself, God bless. Just know that you may need more than 4 meetings per year to do so. And then exculpation provision. This is a provision in most bylaws that says the board members are not liable for acts done in the furtherance of their board. Well, that applies unless you commit gross negligence or willful and wanton misconduct. Very, very rare that I have ever seen gross negligence and willful and wanton misconduct. Not something, if you've hired a managing agent and they're consulting with your managing agent, will likely occur. So here's a blessing. Sometimes the Illinois legislature, like House Bill 189, makes additional hoops you as a community association have to jump through. Well, this is one where they gave you some authority back. The Palm 2 case, right, said no board workshops, no email voting. Well, what that really meant is if you're a 5-person board and 3 of you walked up to the elevator at the same time, you could not talk about association business. A majority of the board could not talk about association business. Well, that became pretty ineffective because what if you want to talk about litigation? What if you wanted to hire people? What if you, for whatever reason, had the lack of wisdom to want to change your managing agents and you wanted to interview contractors or violations? You wouldn't want to do that by having to call a meeting to draw attention to the issue. So the Illinois legislature, effective last year, adopted legislation to make exceptions to the Palm 2 case. In the 6 categories you see up on the slide are what you can do outside of a meeting, which means you can email, you can telephone conference outside of a meeting without giving notice to the owners. Owner forum, we've already talked about it. Good idea, not required. Set reasonable time limits. Let them voice their concerns and questions, respond, and move on. Enough said. Collections and foreclosures. This is not a seminar or a webinar on your collections or foreclosures. What you need to take away from this discussion is there should be clear policies when they're turned over to legal counsel. if you are not collecting your assessments, invariably you are not collecting all the money you need to administer your association. So you need to do that. When you're in the collection process, if you've had to file lawsuits, payment plans are generally not a recommended plan. In fact, there will always be a situation that does make sense. But why is it not recommended? If an individual cannot afford to pay assessments, they cannot afford to make the payment plan. You end up getting defaults and you end up in the same position, not collecting the money. But you need the money because your budget is based upon planned expenditures. So if groups of owners are not paying assessments, you don't have enough money. Foreclosures, you need to be aggressive. There have been some case law updates in the last few years that if a lender does not start paying assessments in a timely manner, while normally the debt gets wiped out except for 6 months worth of assessments, if the lender sleeps on their rights and doesn't pay, the board may be able to go back and collect all the unpaid debt that the court wiped out. Let me repeat that. Let's say you had a unit in foreclosure that didn't pay assessments for 2 years, and you have a $20,000 assessment delinquency. The foreclosure wipes that out, except the buyer from the bank has to pay 6 months worth of assessments. Case law has stated that if the lender does not make timely payments on the assessments, you may be able to go back and collect the full $20,000, not the 6 months that you're limited to. There are some restrictions. You need to speak with your managing agent and attorney, but that's what you need to know. Pitfalls. There are times where you do a collection action. You may evict an owner, and you actually put a tenant in there to recoup money. If you do that, you may need to have the court extend the lease. Be aware of security deposits with landlord-tenant regulations, and you need an ability to end the lease if the unit owner pays the debt. So it's called the kick-out clause, a 30-day right to terminate. The last two topics that I have, and then we're going to open it up for some questions. Electronic communications. There are times where the law takes a little bit of time to catch up to technological innovation. You know, when the Condo Act and the Not-for-Profit Act were adopted, there were electronic communications, handheld devices. The Apple iPhone did not exist. In fact, neither did the Internet. So as technology has changed now where most people have a smartphone of some type, the ability to get information technologically instead of through paper mail has been an issue that was talked about for many years until a few years ago when finally the Condominium Act was amended to say if the board adopts rules to allow for electronic communication, that's part A, and part B, owners opt in, meaning they sign an opt-in form giving an email address to accept notice. You no longer need to give paper notices to the owners. It's really beneficial. It's something every community should entertain and or be doing. Why? Two reasons. One, it gets information to the owners faster. And I'm not talking about social party information at the end of the year. I'm talking about statutory required disclosures and information. So it allows you to get information quicker. Number two, it saves money. You do pay for postage. You do pay for paper. If you eliminate that, you're saving some money on paper and postage. If you're a 20-unit building, maybe not a concern. If you're one of our larger clients with 730 units, that gets costly to make every mailing. And then, thirdly, it just saves paper. It's good for the environment. So what do you need to know? If you want to adopt electronic communication policy, you need to actually adopt a rule. So your managing agent and your attorney will adopt the language of the rule, and that rule will be adopted with an opt-in form, and the opt-in form basically says, the second bullet point here, I, the unit owner, agree to receive electronic communications at the address I put on there until I direct you to remove it or I sell my unit, and that is equivalent to receiving paper notice. That's all it says. Well, with electronic communications came, what about electronic voting? These were adopted by the legislature at different times, but it obviously became obvious. If the board could email out notice of meetings to those that opt in, if the board could send mandated disclosures to owners by email instead of mailing them, shouldn't owners be able to send in their proxy or vote via email? I mean, if an owner is getting information on their handheld device, Shouldn't an owner be able to send in their vote to the extent that their vote is required for something? And the answer is that that makes a lot of sense. Well, it took a little bit of time, but this is another area where the Condo Act allows a board and an owner to opt into electronic voting. There is a specific form that needs to be drafted and signed. It basically says, like the electronic communication, I, the owner, agree to consent to, here's my signature, and I will vote electronically at this address. So if you receive an email at this address, then you can register my vote. This is a way for owners to communicate and register their vote without showing up to a meeting or sending in a proxy. But if you are in a community where part of the social harmony is getting together with your owners to vote in person at annual meetings or for amendments, you do not have to utilize electronic voting. You may always go into a vote and sign a paper ballot that replaces whatever you do electronically. But if you want the ability as a community to register votes, then you need to adopt this opt-in form, and the owners need to sign it. So we are now at that stage where we have quite a few questions from the listeners, so thank you for sending us your questions throughout the presentation. Looking at the volume of questions, we will not get to all of them in the few minutes left, but we will kind of go through some of these in a quick manner. Okay, let's...
Howard, thanks very much. I'm sure the information you provided is very useful to everyone. Hello everyone, my name is Michael Porter. Again, as Howard suggested, from this point we're going to be taking questions. Word of warning, we may go a couple of minutes over. Hopefully you can stick around as long as you can. The questions are from the attendees, as Howard suggested. We will go through as many questions as possible, and I will start with the first question. Howard, the hot topic of the day is that the city of Chicago is supposed to be voting on an ordinance tomorrow. Can you speak to this ordinance relates to the unit order information, telephone numbers, emails?
Yeah.
Can you speak to what that means?
Yeah, so I think for those listeners that in a vacuum are like, what's Mike talking about, I need to at least talk about for a second what it is. Last year, House Bill 189 amended Section 19 of the Condo Act. That was a provision of the Condo Act that was a document request provision that allowed owners to get the telephone and email addresses of all the owners in the communities. For those owners who were upset about that, that caused a lot of consternation. So there was a lot of public uproar about the fact if you live in a condo, any unit owner is entitled by law to get a copy of your email address in your phone. The intent was, the legislator who proposed that said that constituents were complaining that the board would send out information and the people opposed to the board could not get that same access to information out to the owners. Well, so what's the result? Well, public uproar was step one. Step two, where there was a lot of communications from constituents to elected officials. Step three was legislation. Here in the city of Chicago, Aldermans Hopkins and O'Reilly sponsored some legislation earlier this year to basically try and create a Chicago ordinance that said you do not have to comply with the Condo Act. Let me repeat. The two aldermen came up with the proposal to say that you do not have to comply with the Condo Act. And they used as their rationale a legal doctrine called home rule, which is that a local municipality can, through its rulemaking authority, create exceptions to other laws. Well, no good deed goes unpunished. So there are proponents of this legislation and opponents of this legislation. The city ordinance is set to be voted tomorrow. It is anticipated the city will adopt the ordinance, which basically says you as the owner can opt out of providing emails and phone. But you need to be aware there are three different legislation attempt proposals in the state legislature to amend the Condo Act. Two of them are to allow owners to opt out, and then one of them is to specifically say that no municipality can utilize home rule to avoid the Condo Act. So the city of Chicago is taking a step forward to address owner concerns. The state legislature has different proposals, some to eliminate the city's ability to do what they're doing tomorrow, and some to codify at the state level that you don't have to comply. So what do you need to know? The answer is ... to be determined. Stay tuned, and we'll see what transpires tomorrow, and we'll see what transpires with the other legislation.
Howard, the next question. I'm a board member for a condominium and homeowners association. How should we handle an operating budget deficit or surplus?
So, this is a question which is really governed by your condominium instrument. An operating deficit or surplus. What that means is if you budgeted, let's make up numbers, $100,000, maybe in these high-rise buildings that are listening, $1 million, could be more, $1 million for your budget, but you actually only spend $960,000, you have a $40,000 surplus. What do we do with it? Well, before 2014 in the Palm case, most boards would instinctively transfer it to the reserve account. There would be a motion at the annual meeting, and they would just do that. Well, then the Palm case, in that case, we already talked about the holdings, but there were some smaller holdings that related to that association. And one of the issues relating to breach of fiduciary duty was, well, what if the governing documents of a condo state that an excess surplus must be applied to the next year's budget or must be returned? Can the board still transfer it? Well, the conventional wisdom is no. You must comply with your governing documents. No different than if your documents say you must pay assessments, you as a board cannot say, well, Unit 101, you must pay assessments, but Unit 102, we like you, you do not have to pay assessments. You must comply with the document. So if your governing documents state you must return or refund excess income, you must do so. The Condo Act was amended as a part of House Bill 189, but it was really a fruitless endeavor. It says that the board can make its own decision with excess income or surplus unless the condominium documents state otherwise. I will tell you, newsflash, look at your governing documents. Most governing documents state for a surplus it must be returned, and for a net deficit you need to adopt a special assessment or borrow from reserves to pay it. So what do? You need to consult with your legal advisor and your accountant to see what your governing documents say. There's no rule that I can give you. It depends on what your documents say.
Howard, thanks very much. The next question. At our association, we use commissions to assist with special projects. How many board members can be members? Should the chair be a board member?
So there's a distinction between a commission and a committee. Committees must have a majority of board members. Commissions do not have to have any board members. So commissions are recommended instead of committees. It's just a word, but quite frankly, their mission is the same. As a general rule in a community association, both commissions and committees make recommendations, not decisions. Legally, a committee can make a decision, which is why the law states a majority need to be board members. So, should a board member be on a commission? Always a good idea for the board to have a representative in any building commission, because it's just they can represent the pulse of what the committee's thinking. But in terms of who should be on it, it could be any board member. Does it need to be a majority? The answer is no.
Thanks, Howard. Next question. With changes in the Palm Act, can you clarify one last time which decisions or which discussions can occur over email?
Sure. For those of you that are still online, I have just went back to the slide. The discussions are always an open session. The discussion of topics that you may do over email are limited to these 6. You will notice what they are. I will highlight it for those of you that have turned off your screen. Litigation, third-party contracts, employment issues, rule violations, condo assessments, and consultation with legal counsel. What do you not see on here? For those of you that are looking at it, what you do not see are general business about the association. So you can discuss these categories. You cannot discuss general association business. Last question.
Last question. Why can't we invest in stocks and gas futures?
So the answer is you could, but it would not be reasonable, right? Remember I told you your fiduciary responsibility is to act reasonably? And so the court's going to look at what was a decision made and what was it, whether or not it was reasonable. The whole point of investments of reserve funds is to have access to that money in the event of an unplanned emergency. The more speculative the investment, the more likely the decision will be deemed by a court to be unreasonable. So in order to avoid potentially having liability for investing in speculative investments and to have access to that money in the event of an emergency, a more prudent and safer investment, albeit maximizing the return, is the best approach.
This concludes the question and answer portion of the presentation. Again, we'd like to thank you for your participation. We'd also like to thank Howard Dakoff of Levenfeld Pearlstein for this valuable information. As a reminder, this presentation will soon be posted on our website and at liebermanmanagement.com. We also urge you to follow our LinkedIn page, where we post weekly articles aimed at educating and supporting association and corporation board members. Thank you again, and enjoy the rest of your day.